With all of you. So I am Vikas Verma, former Assistant Advocate General and Co-Chairman of All India Lawyers Forum. So let me introduce our guest list and our panelist. Today's keynote speaker, Gaurav Banerjee, Senior Advocate and Barrister at Law and former Additional Solicitor General, Supreme Court of India. And we have with guest speaker, Sebastian De France, Crown Counsel, Public Prosecution Service, Canada. And we have with other guest, Vishwaji Chaudhary, Barrister, and we have with Rajiv Dalal, Advocate, Supreme Court, and Barrister, England and Wales. And we have with Pragya Parijat Singh, Advocate, Supreme Court of India. And also we have with the Chairman, Vinod Kumar Goyal. So today's topic, Barrister in India. It is very important topic for Indians and as well as the foreigners. So now I request to Pragya Singh, today's moderator, Pragya Parijat Singh. So kindly let's start this proceeding further. So over to Pragya Singh.
Thank you so very much, Vikas Verma sir. Hello, namaste everybody. My name is Pragya Parijat Singh. I am a practicing advocate at Supreme Court of India. Welcome to yet again electrifying webinar organized by All India Lawyers Forum. And today's topic is very interesting. We are going to talk about barristers in India, but the term barrister, lawyer, solicitor are so intricately used and interchangeably used that people get confused. And there were so many confusion. So we thought that we are going to keep a session where we will clarify small things about it. And henceforth, with this idea, we organized this session. And we have great personalities today with us who are going to speak about this topic. And just to give a brief introduction, a lawyer or an advocate is a person who's legally authorized or licensed to give a legal opinion. So it is basically an umbrella term that subsumes in itself the term solicitor or barrister. And now the solicitor and barrister is a subset of lawyer or advocate. Now, what is a solicitor? Solicitor in general layman term, I would tell you, somebody who solicits you. So a client is there who goes to a solicitor and he gives some sort of vetting, legal help, some sort of information, ideas, and he drafts the petition for you. And then there is a barrister who comes in the picture and he represents you in the court of law. So this is how it is. And this is a very basic thing that I've told you. But of course, there are a lot of things involved. So not taking much of your time, let me hand over the mic to our esteemed guest, Mr. Rajiv Dalal, who is going to introduce you to our other experts. And thank you so much. May I now call upon Mr. Rajiv Dalal, sir, to take over the mic and introduce other guests. Is there some problem with the connection?
No, he has come.
Okay. Rajiv sir, yes. Welcome back. Handing it over to you. Can you hear me, sir?
Hi, sorry. I think I got a bad internet connection. Can you hear me?
Yes, sir. Yes, sir. So it's your turn. You may please introduce the other guests. Rajiv sir, can you hear me?
Yeah. Okay. Good evening, everyone. I'm Rajiv Dalal. I welcome you all to our 26th session. I think I got a bad internet connection.
No, you are audible.
Okay, I'm going to continue then. Today we are in 26th session of our webinar on the topic barristers in India. I welcome our speaker, Mr. Gaurav Banerjee, Senior Advocate and a Barrister, Mr. Sebastian De France, Barrister, Mr. Vishwaji Chaudhary, Barrister and Advocate, and all our viewers on behalf of All India Lawyers Forum, its chairman, Mr. Vinod Kumar Goyal, advocate, co-chairman, Mr. Vikas Verma, advocate, and the entire executive committee. All India Lawyers Forum is the foremost organization for national legal practitioners, bar associations, and law societies. Established in 2009, it was born out of the conviction that an organization made up of the bar associations could contribute to national stability and peace through administration of justice. In the ensuing years since its creation, the organization has evolved from an association comprised exclusively of bar association and law societies to the one that incorporates individual national lawyers. Our keynote speaker for the evening, Mr. Gaurav Banerjee, is a senior advocate and a barrister, practicing primarily before the Supreme Court of India. Mr. Banerjee graduated from the University of Cambridge in 1989 with first-class honors. Post that, he studied at the Inns of Court School of Law.
I think his internet has snapped again.
May I suggest that I can start,
Yes.
and then I don't really
Yes,
need
sir,
an
yes, sir.
introduction. He
Yes.
can take over after I conclude.
Sure, sir, sure.
Yeah. Okay. Good afternoon, everybody. Thank you to the All India Lawyers Forum for giving me this platform. This is a topic which is of particular interest to me because a lot of people ask me, like Pragya asked, what is this barrister business? Everybody uses this term interchangeably with advocate, solicitor, attorney, uh, sometimes senior advocate. So people get thoroughly confused. So what I just wanted to briefly introduce this by giving you a little bit of history and then telling you a little bit about my experiences of being a barrister and what I think is the way forward for barristers in India. So just by way of background, a little bit of history. Uh, the legal profession, such as it is, uh, originated in some fashion and form, almost, in the time of Edward the First in England, um, in 1272, a long time ago, obviously. And there you had two categories of lawyers for the first time. They were called sergeant and attorney. And you would have heard the word attorney before, but never the word sergeant. And the idea was, and this is the beauty of the split profession between barrister and solicitor, is that the sergeant, now the barrister, is to present the case to the court, and the attorney, or now the solicitor, is to deal with the client. So, as it were, you have a client facing lawyer and you have a barrister who argues the client's case in court. This is called a split profession. It is something peculiar to England, which has now been distributed all over the world in different fashions. Some of them very different. You have somebody from Canada who's a Canadian barrister who will tell you how it works in Canada. But this was the origin in 1272. Sometime in the 14th century, what actually started to happen was that there were various lawyers who were trying to teach students, and they congregated and gathered in areas near the Royal Courts of Justice in London. And if you go to London, you'll find that particular area which is called Legal London, and some inns of court developed. So there were specified geographical spaces. In fact, now there are four inns of court: Lincoln's Inn, to which I belong; Inner Temple, which is also next to, just across the road; Inner Temple, Middle Temple, and then Gray's Inn. So four areas, geographical areas, were sort of grew up organically, and all these students started taking coaching, as it were. It was literally coaching from these teachers. Now, what happened after that was quite interesting. particularly in the time of Elizabeth I and sometime in the 16th century, what happened was that there was a division between the lawyers who were barristers, who went to these inns of court, and other lawyers who were the attorneys who used to deal with the clients. And it was quite classist in the sense that the judges decided that they will only take into the inns of court some special people. So they were called to the bar, as it were, and they became, as it were, barristers. The term attorney, which we find in Calcutta quite often, actually disappeared in England legally in 1874, and it became solicitor. So you have this peculiar split of barrister on the one hand and solicitor in the other. And that is a system which still really continues today. Solicitors are governed by the Law Society, barristers have their inns of court, and there are some quaint customs. Like, to become a barrister, one of the customs is that you have to have a number of dinners at the inn. So when I was there, we had to have, as it were, 24 dinners spread over 6 terms. Spread over various terms. Maybe 6 in a term you could manage, so you could have 4 terms, and you would have these dinners. And it was a very social occasion where you met other lawyers who also wanted to become barristers. So that's the background in England. And obviously, we having inherited our system from England, we also went down the same way. Initially, there were these mayors' courts which were established in Madras and Calcutta in 1726. Then you had what were called the Supreme Courts of Judicature by Royal Charter in 1774 in Calcutta, and then 1801 in Madras, and then 1823 in Bombay. And obviously, the English decided to bring their system over, and all the judges, the Chief Justice and the 3 judges, were actually barristers qualified in England with 5 years standing. And English qualified barristers resisted any Indian vakils and such entering the fray. But this changed in 1862 when the high courts were set up, the chartered courts in Calcutta, Bombay and Madras. And vakils, as it were permitted in some fashion to become advocates. But there were a large number of categories of lawyers. There were advocates, who basically barristers. There were attorneys, who are basically solicitors. There were vakils. There were pleaders. There were mukhtiars. There were revenue agents. There were so many categories. And there were various reforms which I will not go through. But ultimately, in 1961, our Advocates Act said, all this is all ancient history. Let us forget about all this. In India, there will be only one class of lawyer, and he will be an advocate. So legally in India, the only category, there are actually 2 categories. There is advocate, enrolled, and then if you are fortunate enough, senior advocate. And that's about it. But because of this tradition, you still have this massive tradition, particularly in Calcutta and other places, where people still go to England, still study for the bar, still become barristers. And in Calcutta, you have something called the Bar Library Club, which only earlier used to admit barristers, but now admits others. And the rule is, if you want to enter the Bar Library Club, you cannot then file a vakalat. That is the job of the solicitor or the attorney. So that, ladies and gentlemen, that's basically the distinction between barristers and solicitors. There's no technical sanctity to it in India. Interestingly, until 1976, if you were an English barrister, you could automatically qualify to be an Indian advocate, but that went in 1976. But still, the importance of being a barrister in India, I'll just give you a few examples as to how important a role barristers have played in Indian politics, in the legal profession, of course. So, for instance, in the freedom movement, Mahatma Gandhi was a barrister from Inner Temple. Nehru was a barrister also from Inner Temple. When he passed his exam, he said, I passed with neither glory nor infamy. So he was a middling sort of student and he passed the exam. Uh, Vallabhbhai Patel, Sardar Patel, thought it so important to become a barrister that he returned to England. He went to England when he was 36 years old and he became a barrister. And I believe he did very, very well in the examination. He was a barrister of Middle Temple. Jinnah, of course, was a very well-established barrister in Bombay. He was a barrister in Lincoln's Inn. There's a portrait of him in Lincoln's Inn. But these we know about. But the person to whom I realized the importance was Dr. B.R. Ambedkar, who got his who became a barrister at the same time when he was getting his PhD in economics. He did both together. And if you go to England and you go to London and you go to the Inns of Court School of Law, where I studied and became a barrister, in the main lecture hall, there is a portrait of B.R. Ambedkar saying, Father of India's Constitution. And obviously, some little portion of that education would perhaps have been reflected in the document that is the Constitution. So one interesting question is why is it that barristers played such a big role? And perhaps there may be three reasons. One, of course, is knowledge of constitutional rights, knowledge of freedoms. That may be one reason. Secondly, of course, the ability to argue, put across a point. But third, equally importantly, the barrister was self-employed. He could spend long time in jail. He did not have a job that he would lose. So there was a financial backup and possibility of self-employment. Professor Bipin Chandra has mentioned some of these factors. So barristers have played a very important role in our freedom struggle. Of course, we have had very, very eminent barristers who have been judges. No less than 6 Chief Justices of India have been barristers, starting from Sudhiranjan Das, following on to the great Justice Hidayatullah, A.N. Ray, M.H. Beg, Justice Sabyasachi Mukherjee, unfortunately, had a very short tenure, but he was a bencher of Middle Temple. And then the last but not least, Dr. Adarsh Sen Anand, who was, in fact, president of the Inns of Court, a society of which I am the secretary now. Amongst the judges, large number of judges. Recently, Justice Nijjar was the last barrister judge in the Supreme Court. We've had some very eminent judges, lady judges. Justice Sujata Manohar is a barrister. Justice Leela Seth, India's first Chief Justice of a High Court, is a barrister. Was a barrister. She topped the bar exam. She came first in the bar exam, which was an extremely impressive achievement. Along with Justice Sudhimar Roy, who also topped the bar exam. A lot of lawyers, attorneys general, Mr. Daftari, Mr. Milan Banerjee, our late president of our society, Mr. Ashok Desai, all barristers, Mr. Dipankar Gupta, Solicitor General. Now very recently, Mr. Harish Salve, who has now become a QC after becoming a barrister, the latest in the line. A lot of very successful lawyers, Mr. Iqbal Chagla, Mahesh Jethmalani, the list goes on and on. So obviously, it's not a necessary condition of success, but yes, a large number of very distinguished lawyers and judges have been barristers. In fact, there are 2 High Court judges presently who are barristers. One is who I know. One is Arijit Banerjee of the Calcutta High Court, who was called to the bar 1 year after me, and Justice Pratik Jalan of the Delhi High Court are both barristers called to the bar. So this is a background of the flavor, the history, the background. But the real question is, so what? What is so special about being a barrister? And let me tell you about what I think is special from my personal experience. And along with that, let me tell you about what are the requirements to actually become a barrister, and how does it work? So in order to be called to the bar, why is this called to the bar? Where is this bar? It's not the bar which you find in a restaurant or hotel. It's a bar which actually divides a particular area in a court. I'll come back to this phrase called to the bar or barrister, or what do you mean by utter barrister? I'll come back to that in a moment. But what is required to become a barrister? First, of course, there are actually three components. The first component is the academic component, which is you must have essentially in England a law degree, an English recognized law degree. If you don't have a law degree in England, if you're an Indian lawyer, you might have to do a conversion course of 1 year, or you might have to get a UK law degree. So that's the fundamental basic, that's the academic part. That's the easy part to understand. But there is a second and a third part. And that will explain to you the importance which I think there is in order to become a barrister. So the second part of becoming a barrister is what is called the vocational part. Now, this is what is really interesting. So 1 year course, in my time, 1 year course of being called to the bar. So after you graduated with a law degree, I graduated from Cambridge with a law degree, I then joined one of the 4 Inns of Court. And nowadays it really doesn't matter that much, but in the past it mattered which inn you joined. For instance, Lincoln's Inn was more to do with chancery law. Middle Temple Inner Temple had a different profile, but I joined Lincoln's Inn for no better reason than my late father was a member of Lincoln's Inn. Then you do this 1 year course. And in 1989, I had a choice before me. I had graduated. On the one hand was the option of doing an LLM, either a BCL at Oxford or an LLM in the US, but that would be a second academic degree. But I chose instead to do this bar vocational course. It has been called different things at different times: bar vocational course, bar practice training course, bar practice course. But the idea was to have a much more practical 1 year course. Earlier, before 1989, it was actually a very simple thing. You just sat for 6 papers, exam, you passed 6 papers, and you had your dinners and you became a barrister. But in 89, and I was a guinea pig, it was the first time that they changed the system. And we had a 1 year continuous assessment. And some of the papers were really interesting. I mean, apart from procedure and evidence, there was a course on advocacy. There was a course on negotiation. There was a course on legal research, how to properly do legal research. There was a course on opinion writing, how to write an opinion. There was a course, very important course on drafting. There was a course on conference skills, how to conduct a conference. Of course, there was a course on professional ethics. And a lot of this was interactive, how to argue a matter. I remember being videotaped, and I can tell you it is a really bad experience being videotaped. You find all sorts of things: touching your nose, scratching your head, not being clear, not being able to understand what you said, hand movements like this. So it was a real revelation. And 1 year of the vocational training, according to me, really helped me. I still have some of those books, how to cross-examine, basic rules of advocacy. Excellent experience. And then there is the third year, the third step, which is called pupillage. Pupil, to become a pupil, like to a teacher. Pupil, you have a pupil master. You join a set of chambers. You join a set of lawyers. You do 2 6-month pupillages. First 6 months, you're not really allowed to open your mouth. Another 6 months, you can open your mouth. And if you clear the 12-month training, practical on the ground training, then and only then you get what is called a practicing certificate. So there's a 3-stage process. The third stage is negotiable in the sense that supposing you are practicing in India, you practice for a long time, they may reduce it or waive it. For instance, Mr. Salve qualified as a barrister, his pupillage was waived. So there are ways in which that can be reduced or waived. So the real advantage of all this is that if you are a barrister and the training that you get, it really, I thought, gave me a little bit of an edge more than doing this LLM or going to the States. Though I personally do miss out a little, I feel a little bit sad that I could not do an LLM from an American university. So that is really, what barristers are. Barristers essentially are those who argue the matter before the court in simple terms. And the catch is that usually barristers do not then directly talk to the clients. There is a remnants of this. You have the Bar Library Club in Calcutta. I believe you have a barristers club in Patna, but it's no longer the legal position in India is to start off as an advocate. You can do both the work of a barrister and of a solicitor or attorney. It's really a choice that you make. So this is my a sort of helicopter view of the situation of barristers in India. I must mention one last thing. I am the secretary of an organization called the Inns of Court Society of India, which in which we have a very large number of barristers who are members from all over the country. And our president was Mr. Ashok Desai, who unfortunately passed away. He was Attorney General from India. So if any barrister who is not a member of the society is listening to this, kindly reach out to me or Rajiv Dalal, who's also there. And if we can give you any help in what, if you are interested in being a barrister, I'm sure he and I and Vishwaji there can also help you. And finally, could I thank the All India Lawyers Forum for giving me this opportunity to speak to all of you. Thank you.
Is Rajiv sir here? Anyways, thank you so much, sir.
He's like the Scarlet Pimpernel. He fades in and out.
Yeah, I think it's a bad internet day for him. Nevertheless, transitioning to an era where everything is dependent upon internet, but that's how it is. Thank you so much, sir. Even I had a lot of doubts, and I think it has brought me a lot of clarity, because the funniest thing is that no matter whatever degree you do from England, my friends call me hello barrister Pragya. So I tell them, no, I'm not a barrister. So it's like same but different, and they're not able to understand that there is so much difference between it. But thank you so much for taking us.
I will add him. Wait a minute, please. Yes, Mr. Rajiv Dalal is there.
I'm sorry for my internet connection earlier. It failed at the right moment.
No problem, Rajiv sir. So,
I believe we are
considered, and you may now introduce Sebastian sir and
I think I'll introduce Sebastian. Yeah. All right. Our guest speaker for the evening, Mr. Sebastian De France, is a Crown Counsel for the Public Prosecution Services of Canada. He's also a professor and member of the Scientific Committee at University Brevity, teaching law, political science, and international relations, and was a part-time professor of law at the University of Ottawa. He clerked for the Honorable Marie Deschamps of the Supreme Court of Canada and for the Honorable Michelle Robert, Chief Judge of the Quebec Court of Appeal. Sebastian also worked as counsel for the law branch of the Supreme Court of Canada. He has published book chapters and articles on criminal, constitutional, and also labor law, one of which was awarded a National First Prize. He won the Charles Rousseau Public International Law Moot Court competition with his teammates and has lectured on various legal topics around the world. Sebastian completed the course for a Master in Law, Laval University, and studied international law at the Hague Academy of International Law, Netherlands. He holds a degree in law from the University of Quebec at Montreal, a degree in political science from the University of Montreal, and he has also studied Russian and Slavic studies at McGill University. Sebastian is a member of the Law Society of Ontario and of the Law Society of Quebec. Thank you, Sebastian, for joining us. Now over to you. Please address our viewers.
Thank you very much for. Do you hear me okay? Perfect. So thank you very much for welcoming me this morning. It is a great honor. That was a long introduction. Wow. Thanks. I appreciate it. It is a pleasure to be with you this morning. I am not a barrister, but I am as you pointed out, Rajiv sir, I am a Crown prosecutor or Crown counsel. There are different variations, but what is interesting is I go to court very, very often, and Crown Counsel in Canada, basically, and it may not be exactly on point, but we do the work of a barrister, and at the same time we don't solicit anybody because we have one client, and it is Her Majesty. Canada is, we tend to forget about it, but Canada is a constitutional monarchy, and we're part of the Commonwealth, as India is. So what I can tell you, though, what I will talk to you about is more targeted on my experience as a guest speaker around the world. So just to give you a flavor of practical great things that happen to you, but also some challenges that happen to you as well. But before I get there, I just would like to, just because I touched upon the role of the prosecutor, there is a seminal, very, very important decision. Actually, it is a decision that all Crown Counsel almost memorized because it is a very important decision of the Supreme Court. Even though it is a decision rendered in 1954, it does explain the role of Crown Counsel as an officer of justice. And I will tell you what the court says, but afterwards I will comment it briefly so you understand what kind of role the prosecutors have, or Crown Counsel, whatever you call it, have in Canada. So the court wrote that, and I quote here, it cannot be overemphasized that the purpose of a criminal prosecution is not to obtain a conviction. It is to lay before a jury what the Crown considers to be credible evidence relevant to what is alleged to be a crime. Counsel have a duty to see that all available legal proof of the facts is presented. It should be done firmly and pressed to its legitimate strength, but it must also be done fairly. The role of the prosecutor excludes any notion of winning or losing. His or her function is a matter of public duty, than which in civil life there can be no charge with greater personal responsibility. It is to be efficiently performed with an ingrained sense of the dignity, the seriousness, and the justness of judicial proceedings. So basically what it means, there's a few things, and there's a connection with the little talk I will make about the being a guest speaker abroad. Is even though I'm abroad in Vietnam, Indonesia, or of course India, I'm always a Crown. You are a Crown Counsel 24/7. You go out with friends, you have a good time, and then you become silly and do stupid things. Well, you are an officer of justice as clerks of the court, as judges. So this is a very important role. Of course, defense counsel have a different set of responsibilities. But when it says at the end of the quote I just told you, it is with an ingrained sense of the dignity, the seriousness, and the justness of judicial proceedings. Well, it goes beyond judicial proceedings. It sticks to you, if I may say it in plain English, beyond being in court. So, and this is something that is a must-know. These all elements that every Crown Counsel must know. So, to move on to my experience as a guest speaker, some people may think it's all glamorous and it's all nice. Yes, it is partially, because you meet new people. Sometimes you go to cocktails, but this is not what this is all about. And this teaches you a lot about how being a good lawyer and a good barrister, so to speak. Like I said, I'm not a barrister, but I go to court often. So there is some clear analogy to be made here. But it teaches you how really to be a better person to a certain extent. The most obvious example is you speak in front of an audience. You know thy audience. Before, it was said earlier today that, first of all, I have to do a little disclaimer. I apologize, I forgot. So everything I say this morning is not binding on the Public Prosecution Service of Canada. Everything I tell you this morning, it's only on my behalf. So it is important to know your audience. And that's something that also connects to the role of a barrister. What was mentioned earlier in the introduction is to use simple terms. You can be very smart. You can know the entire Oxford or Cambridge English dictionary. But if you don't know your audience, if you start talking to a judge in very using fancy terms, fancy phrases, you will not come across as clear. Clarity is important. And that's something you definitely learn when you give lectures abroad. In some countries, not India, of course, but in some other countries, language may be a barrier. I speak 25 languages. I'm fluent in 18. So, of course, it helps. But when you give a lecture in English, for example, or half English and half in another language, the English part must be very clear. So if you start using very sophisticated terms, nobody will understand you. First of all, people will be bored, and people will not get any benefit from your presentation. The same applies to a lawyer, a barrister, for example, when you're in court, and the same applies to Crown Counsel. You must convey a message that is clearly understood. Well, sometimes you may tell yourself, well, it doesn't look fancy, I look stupid, or well, I don't know my stuff, but I master it. I want to show it. Well, this is not a show. This is justice. And justice to be served, it has to be served in a way where everybody understands what you're talking about. Not only the judge, not only defense counsel, if you're in a criminal case, as I am most of the time, well, always as a prosecutor, not only the accused, but also the public, because the justice is rendered for the public. So the public has to understand. And you will see that's something that is noticeable in Supreme Court of Canada decisions. That's something that is a bit different, slightly different from the decisions rendered for a different set of reasons. It's a different topic, but the Supreme Court of India tends to render very long decisions. And in Canada, it's way shorter. Yes, the decisions are motivated, they're reasoned, there is a rationale that is explained in law. But when I was clerking at the Supreme Court of Canada and also at the Court of Appeal, what I can tell you is that judges are really, it is a serious concern. Even though the law is complex, even though sometimes the legal expressions are not necessarily easy to grasp for everybody, it is a concern for all judges, not only of the highest courts of Canada, but also of the lower courts, to be understood. It doesn't mean you will talk as if you're talking to your buddy, to your friend, at dinner, but you still need to come across as clear. The same applies as a guest speaker. Also know your audience. Know your audience. It also implies know, and I'm sorry, I'm speaking with my hands. I remembered a comment earlier before that barristers shouldn't move their hands around, but I allow myself, if I may, very respectfully, to speak a bit with my hands this morning. I'm a French Canadian, so there's the French blood, I suppose, that comes up all the time. In any event, so what is also important in know your audience is know the culture of your audience. That also applies in court. Know the way it works, the formalities. It's not only as a fluff. It is not useless. Why does it exist? Why is it so formal? Well, it is so formal not only to give the impression that justice is rendered, but also that justice is rendered and to be taken seriously. So, for example, when I was practicing as a Crown Counsel, as a prosecutor in the Canadian Arctic in courts, you had picnic tables in community halls, because in some communities there is no courtroom, because it's so remote in the Arctic. Yes, it's very cold, by the way, minus 30, 40 oftentimes. But in the courtroom itself, the layout is not formal. But it is up to the judge, to the prosecutor, to defense counsel to ensure that it is taken seriously enough so that the public, so that justice not only is rendered, but looks to be rendered. It looks not only in the form itself, but of course with the substance of what is said and discussed. But the underlying statement is what? The underlying statement, when you give lectures abroad, also when you are in court in Canada, in the Arctic, when it's not formal and you have picnic tables with white tablecloth over it, and this is done in community hall, or even at the Supreme Court of Canada. There's a common denominator. What is this common denominator? It is respect. Respect that is shown from you, either as a guest speaker, to the culture, I guess, to be understood, or in the context of when you are a prosecutor in Canada, to show respect to not only the justice system, but to the judicial proceedings that is going on, to show respect to the judges, to the defense counsel, to the public, so justice is rendered. And it is so important that the Supreme Court of Canada gave several, at least I would say 8 or 9 seminal decisions. One that comes to mind is the Queen versus Valente, Valente. That's one of the first decisions rendered by the Supreme Court about this in the 80s, mid-80s. That decision said that not only justice needs to be rendered, but there should not be a bias from the judge, and it shouldn't look biased. So you see how the appearances are important. So the judge should not be biased under any circumstances, any judges, but also it should not look biased. So the way it looks is important. And there's a connection here. So if I'm going to India, for example, and I'm saying this or that, and I say, I first of all, I use too much sophisticated language. Well, in India, it shouldn't be a problem because you guys are amazingly educated, very amazingly. India, as we all know, is the land of several geniuses in various fields. But if I'm speaking to young students and I'm starting using very not understandable words just to look smart, to impress, well, I'm not doing my job. And first of all, it may come across as being snobbish or not respectful. And the same applies to the language that is used. When I go in other countries, if I can use other languages totally or partially, I do, to show respect. And so there's always this big bubble of respect that is necessary when you're a prosecutor, a guest speaker, a barrister. So this is, and that goes back to the ingrained sense of dignity that I was mentioning about when I told you about the quote of the Supreme Court of Canada and the decision in Boucher. So that sticks to you. It never goes away. So something else a bit interesting is just to give you an anecdote. For example, when I went to Indonesia a few years ago, 2 years ago, I think, I almost died. After I gave several lectures, and then I got food poisoning. So I had IV, intravenous, water and salt, whatever it was, I don't remember. And I was in bed. And I couldn't move. I was at the hotel, and then I basically almost, and I don't recommend it to anybody. I did it. Maybe it was stupid, but the result was good. I almost fled the hotel because I had a lecture scheduled the next morning after the ones I gave in Indonesia. I had another lecture scheduled in Australia, and I had to take the flight. Like I couldn't miss my flight. So I basically almost fled the hotel with my lovely and supportive wife, who helped me to go there. And then I don't regret it. I met amazing people in Australia who welcomed me. One person in particular in Darwin, Northern Australia, welcomed me great, in a great fashion. So all of which to say, it's not a road paved all the time with flowers and roses. There are risks. As a guest speaker, when you go abroad, there's like the one I gave you. That's an extreme risk. It never happens except this time. But such risks do exist in court as well. What about defense counsel is disrespectful, or the other side, the other party, if you're a barrister in a civil case, that applies. What about the other party is disrespectful to you? How do you respond? Do you start replying and say, hey, I'm not going to be insulted on or off the record. Of course, if it is on the record, that's a different story, because the judge may intervene and tell the other party to stop, obviously. But if it's off the record, how do you behave? Well, you must behave with dignity. I talked to you about the ingrained sense of dignity, but that should be applicable to all practitioners of the law. If somebody misbehaves, do not respond in the same fashion. You must be respectful. Of course, I'm not telling you you should accept to be verbally slapped in the face, but you must be polite, courteous, and behave with dignity. And that's the same. If you have a question for it, it happens a few times. As a guest speaker, I'm not going to tell the countries, obviously, out of respect that I just talked about, but I got a few questions that clearly showed that some of the members of the audience did not understand what I talked about, and they asked questions that were off. So what do? Do I start telling them, well, you're really an idiot, hey? You didn't understand what I was talking about. Well, let me tell you what I just said 5 minutes ago so you can understand really, because your question is pretty much stupid. Of course not. There's a connection. You never do that. First of all, if you think that, you're already in the wrong path, but show respect. It's not only outside of yourself, but also inside. And sometimes it is difficult, mostly in courts. Of course, when you give lectures abroad, it's always an honor, and it's always an honor that is felt deep inside. So if a question is off, obviously it is your task to bring it back to the road of, okay, this is what I was talking about. I apologize. The person who gave the speech, because I guess I was misunderstood. I must not have explained myself clearly. Then I will answer a question and repeat what I just said, and I apologize again. So profusely. And this is something that happens in court as well. If a judge does not understand you, again, you must be ingrained with a sense of dignity, as Boucher said, the Boucher decision of the Supreme Court of Canada in 1954. The same is applicable everywhere, especially in the, well, not especially, but obviously in the Commonwealth countries, including in India. Respect. So don't start telling the judge, well, Your Honor, I told you 5 minutes ago, please refer to your notes. Or if you were thinking about something else, well, maybe that would be a good idea to wake up. And of course, you don't say such things. But these are reactions, normal human being reactions. That happens. And this is something that must be fought against. And you must become another person. But that new person that you become is a better person. You become a person who is respectful, who is respected because of that, and who basically sets the example. So, and the same as a guest speaker. When you say a few words or you give a lecture fully in a foreign language, or if the audience understands you, please believe me, they will give you back the warmth that you gave to them, the investment, the efforts that you put in, the preparation of a lecture, for example, they will give it back to you. So it goes both ways. So respect is shown. When respect is shown, believe me, respect is given back to you. So thank you very much for listening to me this morning. That was really a pleasure and also an honor to be with you. Of course, I'm staying, but thanks for your time and your generosity. Thank you.
Thank you so much, Sebastian, sir. I'm still stuck at that point wherein you said that you know more than 25 languages and you are fluent in 18 of them. I am amazed. What a polyglot between us. It's so incredible.
And I have to admit, I apologize, I have to admit, I don't speak Hindi, but I started learning it a few months ago, but I will speak it in a year or two better, but now it's horrible. I apologize.
That would be amazing to have you for another webinar, probably after 2 months, wherein you'll be speaking fluently in Hindi.
Dhanyavad.
Again, we are handing over it to Rajiv, sir.
Thank you, Pragya. Now, our final and third speaker for the evening, Mr. Vishwaji Chaudhary. Vishwajit is a barrister and an advocate practicing before the courts at Delhi. Vishwaji completed his LLB from the University of Kent in UK in 2011. After that, he studied bar professional training course at the City Law School in London and got called to the bar at Inner Temple in 2012. Post that, he studied LLM at the University of Cambridge. He is a qualified barrister and is a door tenant at a London-based chambers. His area of expertise include constitutional law, criminal law, and human rights. Thank you, Vishwaji, for joining us. Now, please, over to you.
Thank you very much. Can you all hear me all right?
Yes,
we can.
Perfect. It's an honor to be speaking amongst all of you and to all of you this evening. I'm actually going to start with a story which is, believe it or not, it's absolutely true. So once what happened was I was at an airport where I was grabbing a cup of coffee and I was sitting next to a person and, generally how conversation flows. This is pre-COVID, so we could sit in less than 6 feet away. And we were having a conversation about our careers and our education, etc. And I told the said person, I told her that I've had about 5 or 6 years of education, and all this training has been towards one particular goal, and that one particular goal is to be a barrister. And she said, "Oh, that's quite impressive. That's a long shot in terms of education." I said, "Yes, of course, but the task is demanding, etc." And towards the end of the conversation, when the flights got called, she got up and she closed her notebook and said, "Well, it was an absolute pleasure speaking to you. I know you're a barrister. And it is quite heartening and it is quite strange to know that they are training coffee makers for 5 to 6 years." At which point my jaw sort of dropped, but it was too late. She left. So now there's somebody somewhere in the world who thinks that to be a barrister, which is a coffee maker, it takes you about 5 or 7 years. It might as well, but I'm not a barrister. I'm a barrister. So if nothing else, for that person's benefit, I think it's amazing that we have this conversation today. I'm going to be talking about 2 or 3 things. I'll be very brief. I am aware that we are running out of time. So the first one is about the education of barristers. And the second one is a more general discussion about what are the traits that a barrister should have and what are the sort of things you need to be looking for or developing in case you wanted to pursue a career at the bar. These are not essentially or necessarily mutually exclusive between an advocate and a barrister, but I think they'll give you some idea. So as we already have been told, the education has evolved tremendously. Earlier, it was simply a case where you had the Inns of Court, the 4 Inns of Court, where you would sit with people who are trained barristers, and they would talk more generally about what it means to be a barrister. They'd also be talking about points of law, but now things have, of course, changed. So there are different ways of becoming a barrister. The most traditional one, which I think some of you might be doing, is that you get an undergraduate degree from a UK university, and then you do what has been described numerously as the Bar Professional Training Course. I think the current terminology is the Bptc, which means the Bar Professional Training Course. You do that course and then you become a barrister. But I imagine a lot of you might be in countries where, in countries outside of England and Wales. If you are outside England and Wales, then as you were already told, you do need a degree in law from a UK recognized university. In order to get that, there are again 2 options. One is to do the diploma, the GDL, graduate diploma in law. That is considered to be a conversion degree where they teach you the basics of English law. And then you can become a barrister by, again, doing the Bptc. The rest of it remains the same. There are some universities, for instance, Cambridge offers something called an affiliated degree. If you already have an undergrad, you can take that affiliated degree, and it's a 2-year long course rather than the usual 3 years. The third thing is if you've got a foreign degree, and this is in very, very rare circumstances where you've got something called the qualifying exam, which you sit and then you become eligible to be a barrister after you've completed the Bptc. So the first step is degree. There are 3 ways of doing it. I've explained all the 3 to you. The second step is to do the Bar Professional Training Course. As we've been told briefly, the Bar Professional Training Course is about 9 months long. You can do it part-time. There's an option to do that as well. Attendance requirement is 100%. Even one class missed has to be explained why you missed it. And the course is really, really tough and grilling. Before you take the Bptc, BPTC, there are two conditions. One is that you need to sit for a test, an aptitude test. The test essentially tests, again, two things. One is your critical reasoning, and the other is your ability to analyze. So critical reasoning and analysis are the two things that are tested by this particular test. Once you've set for this test, you're eligible to become a barrister in terms of joining the BPTC. The second thing that you need to do before you commence the course is to become a member of an inn of court. You could choose whatever inn you wanted to do. All of their ups and downs. Some have beautiful dining halls, others have famous members. I am a member of Inner Temple, as Banerjee sir said. He joined his inn because his father was from that particular inn. I joined Inner because my father is from Inner. However, now they're increasingly similar in their functioning. But before you join an inn, please do make sure that you look at what is it that you're looking for in a particular inn, and what are the different scholarships that these inns are offering. A lot of them offer very generous scholarships, which you might be interested in. After you've joined the inns of court, you start and you enroll at one of the BPTC providers. There are currently, if I'm not wrong, about 8 BPTC providers in England and Wales. I went to now called City University, which has been overtaken by University of London. Earlier it was called Inns of Court School of Law. They're all managed by the Bar Standards Board. So the standards are pretty much the same across the board. However, again, look at the scholarships, look at the city you want to be in, and then you can make a call on where you want to do. So just to summarize, the first step is to attain a degree. If you've got a UK degree, well and good. If not, you've got a few avenues there. Number one is, of course, doing the GDL, which is a conversion degree. The second option is to do a course again, and the third one is to, in limited circumstances, you can be called to the bar without having a UK degree. However, that's a very, very small exception which is provided. Now, what's the difference between a master's degree and becoming a barrister? A master's degree is purely and utterly academic. There is very little practical element to it. That is something that you would usually pursue if you wanted to, number one, deepen your knowledge of the law, or if you wanted to have a more in-depth understanding of particular areas in order to go further into doing a PhD, etc. BPTC, on the other hand, is absolutely practical. There is very little theoretical underpinning things that are explained in the BPTC. It is entirely and completely practical. You will be taught things like cross-examining, addressing the court, examination in chief, drafting, pleading, and professional ethics. These are some of the things that you'll be taught. Usually there are about 12 different subjects that you're taught during the course of your BPTC. However, sometimes it varies from provider to provider. So that is what it takes to be a barrister in terms of the education. Now I come to the second part of my speech, which is much shorter than the first one. What are the different skills and what are the different traits that you need in order to become a barrister? There might be different opinions, and I'd be happy to hear what others have to say. The first and the foremost, in my opinion, is integrity. It is completely and utterly impossible to become a barrister without having a sound sense of integrity. So much so that there's a course on professional ethics. Not only do you fail the entire year if you fail that course, but even in other courses, if you make a mistake which is deemed to be unethical, you have to repeat the entire year. So integrity is very, very important. And this is something that I think is more law specific. It is a profession which at the end of the day is considered noble across the world, and that has to be upheld. The second thing that probably is most important is the knowledge of law. Without knowing the knowledge, without having the knowledge of law, and without knowing the legal maxims, you will, of course, struggle. The third one is perhaps what again is across the world, which is courage. You will be representing people who are not the most liked people in the world. You will be representing people who've done some things that are pretty bad, but your job, and this is something that they call the cab rank rule, which means your job as a lawyer is not to judge. Your job is simply to put forward the story of your client. Of course, this is not to say that you will lie or embezzle or say things which you're not instructed to. However, you will have to take on unpopular opinions and make unpopular choices. Fourth is diligence to your clients, diligence to the law. First and foremost, of course, you're an officer of the court, so that has to be kept in mind. Fifth is you must have a sense of brevity and clarity. No judge in the world has all the time to listen to you. You must be crisp, clear, and you must get to the heart of what is it that you're trying to say. The next is your ability to think on your feet. There will be times when instructions or things are thrown at you and you need to respond. You must have that ability to come back with responses that are fair and are reasonable, as well as that they justify your stand. You also must have an eye for detail. Because many times you'll be reading huge files where there'll be that one minor point which you can use in terms of your client's benefit. And final, and perhaps the most important of them all, I would say, is perseverance. You must have that grit and that perseverance to succeed at the bar during your training as well as after. I would like to end with one of my favorite most quotes, which goes that no battle was lost like the one never fought. So this is, of course, a battle which you should encourage yourselves to do. If, of course, as Gaurav sir said, if there's anything that we as a society can help you with, feel free to get in touch. We'll be more than happy to assist you. Thank you very much.
Thank you so much, Vishwaji sir. It was really an informative and quick session, and I'm sure attentive listeners must have garnered a lot of information, because there are small confusions that keeps wavering in their minds, and I think it was a very beneficial session, one of its own kind, organized by All India Lawyers Forum. So thank you so very much, everyone, for such an informative session. We are now moving onwards to the question-answer session. Vikas sir, do you have any particular question as such that are given by the viewers, or should I just ask myself?
Yeah, I have some questions.
Yes, sir. So please go ahead.
Yeah. Mr. Puneet Mittal from the Lucknow want to know that what is the basic difference between the barrister and solicitor?
Yes.
Can I answer that? Essentially, the difference between a barrister and a solicitor traditionally is that the barrister will argue the matter before the court, but the barrister will not meet the client. The solicitor will meet the client and then sort of advise the barrister how the matter is to be argued before the court. So solicitor interfaces with the client and barrister interfaces with the court.
All right, sir.
Thank you, sir. Sir, Mr. Sunita from Chandigarh that want to know that TOEFL exam need to clear primarily or not. So what is the criteria for get admission for the barrister? So sir, can you clarify?
I think Vishwaji, can you clarify this?
Yes, sir. So I think it depends from university to university. If you already have a degree where English has been the language of instruction, which I think in most Indian universities will be, there are exceptions, but I don't think there's a blanket answer to this. I think you're better off contacting individual providers. Also keep in mind that you will have to set the reasoning analytical test for doing the Bptc. So many times they would say, well, if you're able to do that, then you won't necessarily need TOEFL. However, I would recommend that you get in touch with the Bptc providers. If you just Google Bptc providers, there are, I think, about 8 of them. You can get in touch with them directly, and they're quite active in replying swiftly.
Sir, also, I have a small query in my mind. There is a prerequisite that after you're done with your Bptc course, you need to have a mini pupillage. So the problem that students now here are facing, because I do have certain friends who've done a Bptc course from here, but they say that being an outsider, they do not get a pupillage, and usually they prefer to have students who are from United Kingdom. So is there any particular strategy or anything that you would like to suggest to students that they can incorporate in their CV or something like that, so that it gets easier for them to get access to pupillage, because until unless you don't get pupillage, everything reduces down to zero, and you go back to your country with a barrister degree, and then again you have to give a local exam to start practicing at the court. So, if you would like to answer.
Actually, the problem is that you should start applying for many pupillages as early as possible, because I'm a member of Essex Court Chamber. And you are absolutely right. There is some major problem in non-EU citizens or non-English citizens getting pupillages. Because the moment you say that you don't have rights of residence in England, then some of the chambers don't take you on. But I think the answer is to do as many mini pupillages as possible. Those 2 days, 3 days, 2 days, 3 days, and apply to as many cases as possible. uh, the more you apply to, may get 9 out of 10 rejections. But somewhere, if you keep going, you will get something. I mean, I agree it's difficult, but that's the only solution. I mean, I can't think of any. Vishwaji may have some other views on it.
Yes, I absolutely agree. I mean, I apply to as many as possible. I'd also recommend that there are two ways of commencing the BPTC. One is that you apply after you get a pupillage. I think that's the best way to do it, because your chambers sometimes will also fund it entirely. So it probably is a good idea to apply for pupillage even before you've commenced the BPTC, after your undergraduate degree. That way you are home and dry by the end of the year. Having said that, the bar is shrinking. Especially after the Brexit and so many other things happening to the economy. Legal aid has gone down drastically in the United Kingdom. So getting a pupillage is very, very hard. For those who do not manage to get pupillage, my advice is do not be disheartened, because BPTC is really a skills course. And the skills that you're taught on it are completely and absolutely transferable, whether it is in the courts of India or, as we've heard, in the courts of Canada. So the skills that you learn in this course are really, really transferable. And even if you don't get pupillage here, it's a good idea to come back and do it. Of course, ideally you would get a pupillage even before you start the course.
All right. Yeah, because I think the 5-year law courses and the colleges nowadays try to provide summer vacation schemes to students, so it gets easier for them to have access later on. And I think, as sir said, that you would get a 9 out of 10 rejection, but even if you get access to one of it, it eventually starts building up, and then when one accepts you, the other places also start accepting you. So I think the key lies in the fact that we should not get disheartened, and we should just keep on applying, and eventually it will come to us. Thank you so much, sir. Vikas, sir, any other question that you would like to take from the audience?
I have one question. Durgesh Gupta from Mumbai. So my next question to you, Vishwaji Chaudhary, can you explain the GDL a bit in detail?
Yes, of course. GDL stands for Graduate Diploma in Law. It essentially is a course. By the way, mind you, as we speak, changes are happening on the ground, so they might change many of these courses. But I think the principles would remain the same. So GDL, in many circumstances, is a course which is called Graduate Diploma in Law. UK LLB is 3 years. GDL, on the other hand, is 1 to 2 years. So that's really a course which condenses the undergraduate LLB degree from the UK into a shorter course where you're only taught the bare essentials of the law, and then you can then you can proceed on to the BPTC.
Thank you. My next question to Sebastian De France, sir. So what is the scope of barrister in Canada? So is there any difference from the England?
With respect to the practice, or with respect to possible admissions?
So with respect to practice, I suppose.
Okay. Yes, a lot. As in all Commonwealth countries and other countries as well, there are some practical things that are similar. We have robes in court. We are differential, and all the common law principles, at least in criminal law, applies, but also in civil law when it's in the English-speaking Canada. Are there differences? Well, honestly, I will say a few examples, but in and of itself, that would be an entire topic to be discussed about the differences between the UK and India, and also between the UK and Canada. There are differences, many differences with the law itself. For example, the law is not necessarily, of course, it is the same in India. The same principles are not interpreted in the same way as the UK. But basically, in some, Canada is not a copycat, and India is not a copycat as well of the law in the UK. Beyond cultural differences that also, of course, impact on the law itself, there are also principles that are interpreted differently by the highest court, by the Supreme Court of Canada. In various circumstances. Sometimes it is slight differences, it may be procedural, whereas the big principles are the same. There's one thing that I would be remiss to not mention. I have to mention this, but there's one section of the criminal code, I believe it is section 8, if I'm not mistaken, but this is at the very beginning of the criminal code in those sections, that when there is no, and that's quite interesting, actually, it's the most interesting point to answer the question very briefly. But when there is there's one thing that is not provided in the law of Canada, the criminal law of Canada. There's one section, maybe section 8 at the very beginning of the criminal code, that says that the law of England, may be important into Canadian law. So there's still there are close ties with the United Kingdom in that regard. But otherwise, sometimes, even though this is not necessarily strictly followed, so if there's a gap, the Supreme Court of Canada will not necessarily resort to the law in the United Kingdom. However, of course, it is so close that Canada will, and Canada's Supreme Court judges, I assume, will certainly at the very least consult what is done in the United Kingdom, and I can rely for this on my experience as a clerk at the Supreme Court and the Court of Appeal in Quebec in criminal law cases. So that would be my answer. But again, it could be a 1-hour topic. It's so interesting. Like a triangle, India, Canada, and UK, what are the differences and what are the similarities? How does it impact, et cetera, et cetera? So it could be never ending. But that's what I will answer for now. But thanks for the question. Thank you very much. Very interesting.
Thank you, sir. So to all our viewers, in case if you have any other query, there is a WhatsApp number that is flashing on the screen, and you may write your questions and we'll try to get back to you. Not just that, the recording of the webinar will also be on our Facebook page and on YouTube. All you need to do is just search for All India Lawyers Forum and you'll have the access to the link. Now I will hand over the mic to Vikas sir for giving a vote of thanks. And thank you so much for joining us today.
Yeah, definitely. Thank you, Pragya. So, I am Vikas Verma. On behalf of All India Lawyers Forum and behalf of our national and state executive, extend a hearty vote of thanks to our today's keynote speaker, Mr. Gaurav Banerjee, Barrister, Senior Advocate and former Additional Solicitor General, Supreme Court, and Sebastian De France, Crown Counsel, Public Prosecution Service, Canada, and Mr. Vishwaji Chaudhary, Barrister, and Mr. Rajiv Dalal, Advocate and Barrister, and Vinod Kumar Goyal, Chairman, All India Lawyers Forum, and Pragya Parijat Singh, Foreign Coordinator of All India Lawyers Forum. So today's lecture is very motivational and informative for our all participants. We are much obliged to you for sharing such valuable and unique information with our participants and spare your valuable time for us on one call. I also would like to give thanks to all participants of today's webinar. And finally, I would like to give special thanks to all strong pillars of All India Lawyers Forum, national and state executive team members, our national chairman Vinod Kumar Goyal, President Abhinav Singh, Vice President Rasmi Bansal, AOR, Secretary Vikrant Dhama, Advocate, and Naveen Gupta, Registrar Mr. Balraj Puri, Advocate, National IIT Head Mr. Manvinder Singh, Foreign Coordinator Pragya Parijat Singh, Academic Coordinator Dr. Mohit Sharma and Shweta Bajaj, Delhi Coordinator Mr. Sandeep Garg, Punjab In Charge Vikramjit Jalana, Chandigarh in charge Mr. Amandeep, Haryana in charge Udit Mehndi Datta, Jharkhand in charge Dipesh Kumar Nirala, UP in charge Sagar Sharma, MP in charge Dharmender Singh Malviya, Andhra Pradesh in charge Anil Kumar Jaldi, Gujarat coordinator Bhagya Uday Mishra, Jammu and Kashmir in charge Mr. Farooq Sofi, Assam in charge Vishwaji Chaudhary, West Bengal in charge Jaha Ara and Surjit Ghosh, and Maharashtra in charge Durgesh Gupta, Rajasthan in charge Sandhya Singh, Tamil Nadu in charge Chandrasekhar, and our student wing Mr. Subham Singhal, Miss Riya, Miss Bhagya Shri, and all other respected team members. So you spoke very well, and we got a very good knowledge on today's topic. So once again, I extend my vote of thanks on behalf of All India Lawyers Forum. Thank you so much.
Thank you so much.
Thank you, sir. Thank you very much.
Thank you very much.
Thank you.
Thank you very much.